I mean, so many of our clients, they have, medical directors that, just kind of hang their shingle on the wall, but they're not actually working there inside the walls of the practice. So what role do medical directors actually play in compliance? What liability do they have when a practice might be administering GLP-1s that they're a medical director of?
It really depends on the state and really depends on how much enforcement is in a particular state on this area. So some states kind of take a laissez-faire approach, maybe because the government is understaffed or maybe because it's not a priority. So in some states, it's okay for a medical director to be somewhat detached. Legally, the requirement may be that you have a medical director and that they're in every state to supervise something, they have to be competent in that procedure. So if your medical director does not know themselves how to do GLP-1s or the basics of GLP-1s or the basics of Botox, and they're supervising you doing that, if there's ever an issue like a malpractice claim, a board investigation, one of the things they're going to ask for is to swear under oath about this person's training and to provide their training certificates. So you should have a medical director who's competent in what they're supervising. Otherwise, how can they competently supervise? Some states have requirements like about distance of the medical director or board certification. A lot of states don't. So a good rule of thumb is have a medical director who knows the procedures that they're supervising, that is involved in your practice, at least on a monthly basis, at least via a phone call, where you have a record of them speaking to you and discussing, what's been going on and how you're doing and any complicated cases. That would be the bare minimum, I think, in any state